What do you say when a cop walks up, says, "We got a call," and starts fishing for answers from you? If you answer too fast, you can give them the reason to keep digging. That one vague sentence can turn a normal stop into a full investigation in seconds. Hit subscribe right now because what I'm about to show you could save you from saying the one thing that keeps you detained. Smash like too, because when your nerves hit, you'll want this video easy to find. Most people have no idea how dangerous those 4 words really are. "We got a call" sounds official, solid, and final, but it's often vague on purpose. It makes you feel like they already know everything, so you start filling in blanks they never had. That is where people get hurt. In this video, you're going to learn the first sentence you say before answering anything, the exact words that shut down the phishing, the mistake that turns a vague call into probable cause, and the one question that tells you whether you can walk away or not. I've analyzed over 200 body cam videos, and the pattern is always the same. The driver or the person on the sidewalk starts trying to sound innocent, then the officer gets more words, more details, and more reasons to stay. Here's the reality. "We got a call" is not magic. It does not erase your rights. It does not mean the caller was honest. It does not mean the caller saw clearly. It does not mean the officer has enough to search you, arrest you, or keep you talking forever. But if you act like that sentence already proves you're guilty, you do the officer's job for him. You start explaining where you were, who you were with, what you had in your car, and why you look nervous. That is exactly how a weak stop gets stronger. You think you're clearing things up. You're really building this story against yourself. Let me show you exactly how to stop that from happening before your own mouth traps you. The first move is simple. Do not answer the story. Challenge the status. When the officer says, "We got a call," your brain wants to ask, "About what?" Don't start there. Start here. You look at the officer and say this: "Officer, am I being detained or am I free to leave?" Those exact words. Say them calm. Say them once, then wait. That line works because it forces the moment into legal categories instead of emotional fog. Either you are being detained, which means the officer is officially holding you, or you are free to go, which means you do not have to stand there and talk. There is no third secret category where you're somehow required to stay and help them investigate you just because they sounded serious. This comes straight from Supreme Court rulings. Terry versus Ohio says police need specific facts to briefly detain someone. In plain English, they need more than a vibe. They need more than your face, your clothes, or your nervous hands. And in Florida versus JL, the court said an anonymous tip by itself was not enough for a stop and frisk in that case. In plain English, a random caller does not automatically cancel your rights. Bad way. Most drivers say, "A call about what? I didn't do anything." Then they start filling the silence with extra facts the officer never had. Good way. Smart drivers say, "Officer, am I being detained or am I free to leave?" Then the officer has to define the stop before you define yourself into trouble. Watch what happens when you use the bad line. The officer says they got a call about a suspicious person or a reckless driver. You panic. You say you were only looking for an address. Then you add that you were on your phone for 1 second. Then you say your friend was yelling and that's why the car swerved. Now the officer has more than a vague call. He has admissions. He has details. He has a reason to keep pressing. That is how you turn smoke into fire with your own words. Now watch what happens when you use the right line. Officer, am I being detained or am I free to leave? If the officer says you're free to leave, the game is over. Leave calmly. If the officer says you are detained, now the line is clear. He is taking responsibility for that detention. Defense attorneys use this exact line in court because it exposes whether the officer really had a legal basis or was just hoping you would talk first and make the stop stronger later. Here's the trick they don't want you knowing. A vague call feels powerful because it sounds like hidden evidence. But hidden evidence is not your problem. Your problem is opening your mouth before they commit to a legal position. Make them choose first, detained or free to leave. That question keeps you out of the danger zone where you talk yourself into a longer stop. Think you could stay that calm when an officer drops that line on you? Let me know in the comments because most people don't realize how fast this moment gets real. Now, let's talk about what you say if the officer says, "Yes, you are being detained." This is where people usually melt. They think detention means they have to answer every question. It does not. If you're driving, you give your license, registration, and insurance when required. In some states, if you are lawfully detained, you may have to identify yourself. But after that, your job is not to explain your life. Your job is to protect your silence. Here's exactly what you say. "Officer, I choose to remain silent. I want a lawyer." word for word. Memorize that line. Listen closely because this is critical. Silence is strongest when you clearly say you are using it. In Salinas versus Texas, the Supreme Court said a person who wants Fifth Amendment protection outside custody generally has to clearly claim it. In plain English, just standing there awkwardly is not always enough. You need to make it clear that you are choosing not to answer. That is why this line matters. It does two things at once. It shuts down the questions and it tells the record what you were doing. You were not confused. You were not hiding. You were invoking your rights. Bad way. Most drivers say, I can explain. Then they answer 5 questions, change one detail, and suddenly look dishonest. Good way. Smart drivers say, officer, I choose to remain silent. I want a lawyer. Then the fishing trip loses its easiest bait. This is 100% legal. You do not have to solve the officer's mystery for him. You do not have to explain why the caller was wrong. You do not have to talk your way out of handcuffs with perfect words under stress. In fact, talking is usually what buries you. Former police officers have confirmed this works because they know most roadside investigations get traction from voluntary statements, not genius detective work. The more you talk, the more chances you give them to say you changed your story, sounded nervous, dodged the question, or admitted a key fact without meaning to. A lot of people think asking for a lawyer makes them look guilty. That fear destroys people. You are not there to look innocent. You are there to stop damage. Innocent people ask for lawyers every day because innocent people get misunderstood every day. Witnesses are wrong. Callers exaggerate. Neighbors lie. Exes get revenge. Strangers misread what they saw. Your calm silence protects you from all of that. Legal experts agree this is your strongest protection when the officer wants conversation more than facts. And if the officer keeps pushing anyway, you do not get dragged into a debate. You repeat the line. Officer, I choose to remain silent. I want a lawyer. No speech after that, no sarcasm, no angry lecture about your taxes paying his salary, just the line. Clean, boring, repeatable. That is how you keep your rights alive under pressure. The next danger is the fake casual ask. The officer says they got a call, then after a few minutes comes the soft voice. You don't mind if I take a quick look, right? That is where a bad stop becomes a search. Here's exactly what you say. Officer, I do not consent to any searches. Word for word, keep your voice steady, keep your hands still, then stop talking. That sentence matters more than most people realize. In Schneckloth versus Bustamonte, the Supreme Court said a consent search can be valid if your consent was voluntary. In plain English, if you say yes, the fight later gets much harder. The court does not require police to prove you got a perfect lesson on your rights first. Your nervous yes can still count. That is why your no matters so much. Here's the reality. You are not being rude when you refuse. You are protecting the very barrier that stops a weak hunch from becoming a legal search. Bad way. Most drivers say, sure, go ahead, I've got nothing to hide. Then the officer finds something old, borrowed, forgotten, or misunderstood. Good way. Smart drivers say, officer, I do not consent to any searches. Then the officer has to rely on real legal grounds instead of your permission. Watch what happens when you consent. The officer opens a bag that is not even yours. He finds a bottle with no label. He finds cash. He finds a tool that looks suspicious out of context. Maybe everything is legal, maybe none of it is, but now you are standing there while your whole life gets interpreted by somebody who already thinks the call might have been right. That is a terrible place to be. Now look at the smarter path. You refuse consent calmly. If the officer has lawful grounds anyway, he may still search. Your refusal does not create a force field, but it protects the record. It shows you did not waive your rights. It gives your lawyer room to fight later. This is 100% legal. You are allowed to say no. You are allowed to protect your car, your bags, and your pockets from a fishing expedition based on a vague claim. And notice how all 3 tactics work together. First, you ask whether you are detained or free to leave. Second, if detained, you invoke silence and ask for a lawyer. Third, if they push for a search, you refuse consent. That combination makes the stop narrow. It keeps you from volunteering your own evidence. It keeps the officer from using your panic as a ladder. Most people already clicked away. If you're still here, you're in the top 10%. Drop a comment saying I'm still here because the next move is the one that keeps you from turning calm into conflict. Now let's cover the part where people accidentally sabotage themselves by arguing instead of complying. If the officer gives a lawful order, follow it. Step out of the car if lawfully ordered. Keep your hands visible. Do not reach around fast. Do not square up. Do not try to win the moment with attitude. But do not confuse compliance with surrender. You can comply physically and still protect yourself verbally. Here's exactly what you say. I will comply with lawful orders. I do not consent to searches. I choose to remain silent. That line keeps you safe without feeding the stop. Pennsylvania versus Mims said officers can order a driver out of a car during a lawful traffic stop. Hebel said that in some states, during a valid stop, a person can be required to identify himself. In plain English, you may have to move. You may have to identify yourself. But that does not mean you have to answer endless questions about where you were, what the caller said, who was with you, or what is in your trunk. That is the line people miss. They think if one order is lawful, every question must be answered too. Wrong. Bad way. Most drivers say, "Why are you making me get out if I didn't do anything?" Then the stop gets tense, the officer gets alert, and you start looking combative on camera. Good way. Smart drivers say, "I will comply with lawful orders. I do not consent to searches. I choose to remain silent." Then you stay safe, calm, and hard to manipulate. Let me show you exactly how that helps. When you argue, the stop becomes about your behavior. When you comply and stay quiet, the stop stays about the officer's reasons. That shift matters. If this ends up reviewed later, calm compliance looks very different from roadside debate. And that difference can save you from extra charges like obstruction, resisting, or disorderly conduct being thrown into the mix just because the original reason was weak. Now put the whole legal picture together. Terry versus Ohio says police need specific, reasonable facts to detain you. In plain English, they need a real reason, not just a hunch dressed up as confidence. Florida versus JL shows that a bare anonymous tip is not always enough by itself to justify a frisk. In plain English, someone called does not automatically mean they get to search your body. Schneckloth versus Bustamonte explains why your yes to a search can hurt you later. In plain English, if you consent, you make the challenge much harder. And Salinas versus Texas is why your silence should be clear, not fuzzy. In plain English, say you are remaining silent instead of hoping the law reads your mind. This comes straight from Supreme Court rulings, and once you understand that, you stop treating "we got a call" like a magic spell. Now imagine the real scene. You're driving home after work. Lights flash behind you. You pull over. The officer walks up and says, "We got a call about a driver matching this car." Your stomach drops. Wrong way. You panic and say, that wasn't me. I was just on my phone for a second. I was trying to find my house. My friend was texting me." In 10 seconds, you admitted distraction, gave a timeline, and handed over more facts than the caller ever gave. Then the officer asks if there's anything illegal in the car. You say no and laugh. He asks to take a quick look. You say sure because you want to seem helpful. Now the stop is wide open. Right way looks totally different. You hand over the required documents. Then you ask, "Officer, am I being detained or am I free to leave?" If he says detained, you say, "Officer, I choose to remain silent. I want a lawyer." If he asks to search, you say, "Officer, I do not consent to any searches." If he tells you to step out, you step out and say, "I will comply with lawful orders. I do not consent to searches. I choose to remain silent." That is calm. That is clean. That is controlled. You are not fighting the stop. You are refusing to build the case for them. And if the original reason was weak, your discipline keeps it weak. Coming next week, what to do when cops ask to search your phone. Subscribe because that video could save your entire life from being exposed when one simple yes opens far more than you think. So here's the recap. When cops say, "We got a call," do not rush to explain. First, ask whether you are being detained or free to leave. If you are detained, clearly say you choose to remain silent and want a lawyer. If they ask to search, refuse consent with plain words. And if they give lawful orders, comply physically without talking yourself into deeper trouble. That is the power here. You stop reacting like a scared person and start responding like a prepared one. Hit subscribe so you catch next week's phone search video. Smash that like button if this just changed how you'll handle a stop. And drop a comment telling me which exact line you're going to memorize first. Stay calm, protect your mouth, and stay safe out there.